Thank you. Right, can I welcome everyone to the Justice Committee's 31st meeting in 2013. I ask everyone to switch off mobile phones and other electronic devices completely, as they interfere with the broadcasting system, even when switched to silent. No apologies have been received. I welcome our new member to the committee, Christian Allard. I'd also like to take the opportunity to thank Colin Keir, who made his escape, for his work on the committee over the last couple of years. Notre premier point de l'ordre du jour est d'inviter Christian Allard de déclarer les intérêts pertinents à la compétence du comité. Our first item is to invite Christian Allard to declare any interest relevant to the remit of this committee.
Bonjour. Thanks very much for this. I refer members to my declaration on the Parliament website.
Very much. Item 2, decision taking business in private. I would ask you to agree to take items 4 in private and 5. Item 4 is consideration of our draft report to the Finance Committee on the draft budget 2014-15. Item 5 is consideration of our work programme. Can I have your agreement? Thank you. Item 3, victims and witnesses. Scotland Bill, as I've said to, and for the benefit of the Cabinet Secretary, who knows how long he's going to be sitting here, I intend to do this for 2 hours. If I look as if people are wilting on the vine, I may take a little break, unlikely, after which time we'll move on to consideration of our budget report, as that does need to be signed off today. If we do not get through all the amendments today, we can return to them next week. I know you're delighted about that. Absolutely. Can I welcome the Cabinet Secretary for Justice and his officials, and can remind members that the Cabinet Secretary is giving the evidence and responding to the amendments, that the officials are here strictly in supporting capacity and cannot speak during proceedings or be questioned by members. Okay, just in case anybody feels that they're going to do that. Members should have copies of the bill, the Marshall list and groupings of amendment for today's consideration. And can I thank the Cabinet Secretary and all his officials for attending today. Yes. Thank you. I now go on and I start with, I call Amendment 74 in the name of Margaret Mitchell, grouped with Amendments 75, 76, 20, 22, 23, 26, 39, 40, 41, 49, 48, 50 and 51. Margaret, can I ask you to move Amendment 74 and speak to all amendments in the group if you wish?
Okay, thank you, Convener. This amendment is in line with the Committee's Stage 1 report recommendation, which is to provide a definition of victim on the face of the bill, as it appears somewhat strange that a bill which confers a whole range of rights on victims of crime doesn't actually include a definition of the term victim. The inclusion of a clear definition will assist in providing clarity to individuals in what may be traumatic circumstances, avoiding further distress and anxiety, and it will assist a qualifying person in determining and complying with their duties and obligations under the provisions of the proposed bill. The amendment is intended to cover both natural persons and legal entities in 3 sets of circumstances. In the first instance, in cases where the person has a crime committed directly against them. Secondly, where a relative or dependent of that person suffers harm as a result of a crime committed against that person. Thirdly, where the person suffers as a result of intervening to help another person against whom a crime is being committed. Harm is defined in such a way as to include physical, mental or emotional harm, as well as economic loss. The amendment also requires Scottish ministers to set out by negative instrument what family members this definition will apply to, as is the case elsewhere in the bill. Amendment 75 and Amendment 76 are consequential to that amendment, Convener, and I move Amendment 74.
Very much. Cabinet Secretary to speak to Amendment 20, please, and other amendments in the group if you wish.
Thank you, Convener. Amendments 74, 75 and 76 in the name of Margaret Mitchell will insert an overarching definition of victim into the bill and make some minor consequential amendments. In its Stage 1 report, the Justice Committee recommended that the Scottish Government give full consideration to including a definition of victim on the face of the bill in order to provide clarity. While I do not consider such an overarching definition to be necessary, I indicated that I was happy to consider further whether any additional clarity was required in relation to the use of the word victim in the bill. The word victim is used and understood without definition by justice organisations and victim support organisations throughout Scotland. I consider that by attempting to insert an overarching definition of such a clearly understood term, we significantly complicate matters and risk inadvertently excluding individuals who should benefit from the proposals in the bill, or including those who would not fall into any reasonable interpretation of victim. For example, the definition in Amendment 74 hinges on an offence having been committed against a person. This could imply that a conviction is necessary in order to establish that an offence has been committed against the victim. There is no reference to the situation where an offence is alleged to have been committed against a person. Given the concerns raised at stage 1 about the presumption of innocence, I think the current drafting of the bill, which refers where necessary to those who appear to be victims and to the offence or alleged offence, is preferable, and also ensures that those persons who appear to be victims are treated as such before the trial or conviction. Further, the definition provided in Amendment 74 only covers offences against the person, so offences against property may not be covered. There is a risk that persons whose property has been vandalised would not be classed as victims under this definition. In addition to potentially excluding some victims, the definition also includes some who, I would argue, do not need to be covered. In particular, the inclusion of the prescribed relatives of all victims. Not only victims who have died as a result of an offence, but also relatives of victims who have suffered any harm seems a step too far. While I absolutely agree that relatives of victims should benefit from the proposals in the bill, in some circumstances the idea of treating the relative of someone who has had their wallet stolen and so has suffered economic loss, as set out in Amendment 74, as a victim themselves seems hard to justify. For these reasons, I consider it better to qualify and explain the use of the term only where necessary and to make it applicable to the circumstances as in the bill at present. On reflection, however, I do consider that some minor amendments are necessary in order to ensure that certain proposals in the bill extend to the family members of the victims as well as to the victims themselves. Amendments 22, 23 and 26 seek to ensure that where a person's death has been caused by a criminal offence, prescribed relatives of that person will be able to request information under Section 3 of the bill in the same way that victims and witnesses can. Similarly, Amendments 39, 40, 41, 48, 49, 50 and 51 ensure that the Victim Surcharge Fund can be used to support those who appear to be victims in order to offer immediate support prior to any criminal proceedings having commenced, and to support prescribed relatives of victims as well as victims themselves. I think it's only right that families of persons whose death has been or appears to have been caused by a criminal offence or alleged offence are able to seek and receive information in relation to that particular offence, and that families of persons who are or appear to be the victim of crime are able to access support services through the Victim Surcharge Fund. And I believe that my proposed amendments achieve this. And finally, Amendment 20 is a minor technical amendment in my name to reflect that an order prescribing the relatives of a victim for the purposes of Section 2 is made under subsection 5 of that section. I invite the committee to support my amendments 20, 22, 23, 26, 39, 40, 41, 49, 48, 50 and 51, and urge Margaret Mitchell to withdraw Amendment 74 and to not move Amendments 75 and 76.
Thank you very much, Cabinet Secretary. Elaine Murray.
Yes, I understand that Children First are supportive of Mark Mitchell's amendment in that in some cases, for example, in domestic abuse, where children may be treated as witnesses, but in fact they are victims because of their vulnerability and through the circumstances under which the offence has been committed. But my feeling, actually, my concern about this was having it on the face of the bill was maybe over-prescriptive, and that if the definition was not appropriate, you then have to come back and amend primary legislation, and that it would be better addressed perhaps in regulation. I just would ask the suggestion from the Cabinet Secretary that some of his amendments would actually achieve the ability to have that definition through regulation rather than on the face of the bill, and in which case I think that probably would be a preferable approach to the issue.
And Cabinet Secretary, do you wish to respond to that?
No, I think I agree with Elaine Murray. We are in a moving feast. The nature of crime, the nature of victims has changed. People are victims of internet crime. 20, 30 years ago, that wouldn't have been conceived of. We don't necessarily know what the situation might be in 5 years or 10 years, and I think we've therefore got to treat the victim as we find them in the world in which we live. So I agree with Elaine Murray.
Margaret, to sum up, please.
Yes, thank you, Convener. I think the amendments the Cabinet Secretary has tabled are to be welcomed. I don't think they're necessarily mutually exclusive of putting a definition of victim on the face of the bill. However, I do take the point, and I'm open to looking at this again at stage 3, particularly on the concern that he's highlighted this morning, which was raised at stage 1, that the use of the term victim in the bill sometimes referred to cases where the guilt of the accused had not been proven in court. And I think the faculty of advocates had argued that this approach may give rise to the implicit assumption that the victim's allegations are true, thereby potentially undermining the presumption of innocence of the accused, as the Cabinet Secretary has stated. So I'm still of the mind that there is good reason for a definition to be on the case of the bill, while the Cabinet Secretary might be quite sure that he's clear in his mind what a victim is. I think the 3 situations outlined in the amendment do clarify exactly who's included, and I'm happy to look at these again and to come back at stage 3 with a revised proposal. I should say that this is an amendment which is supported in principle by the Law Society of Scotland. So with your permission, I won't move at this stage.
You've moved it, so withdraw.
Withdraw.
Into withdraw.
Withdraw.
Thank you very much. Does any member object? No. I call Amendment 55 in the name of Elaine Murray, group with Amendments 56 and 57. Elaine, please to move Amendment 55 and speak to the other amendments in the group.
Well, I'll commence by moving Amendment 55, otherwise I'll forget by the time I get to the end of what I've got to say. Amendment 55 ensures that when...
I nearly forgot to remind you to move it, so there you are. We'll get into this shortly. Get our sleeves rolled up. Right, off you go.
Amendment 55 ensures that where a victim or witness is a child, the information is provided by the persons listed in subsection 2 is in a form that may be understood by that child. And Amendment 56 ensures that the rights, needs and wishes of children who are victims or witnesses are considered by the persons listed in subsection 2. Amendment 57 is included in order to ensure that the definition of child is consistent throughout the bill. Evidence suggests that over 60% of the people in the youth justice system have difficulties with speech, language and communication. And obviously that makes it even more important that information should be accessible to those children. And indeed, it's the difficulties that many young people have with communication within the justice system actually make it more difficult for them to navigate their way around the court system. At the moment, there's no requirement for anyone involved in criminal proceedings to communicate with children and young people in formats and ways which best suit their needs. And this could include things, for example, like sending text messages about the date of a trial, sending out a leaflet, or even emailing a link to a video where a young person can actually see the information that they require to become involved. And I'm therefore hopeful that in the future, because of the range of ways in which people communicate now, in particular young people communicate these days, that the bill actually incorporates the need to communicate in some of these ways. And I'm therefore hopeful that the Cabinet Secretary and Ministers would be amenable to certainly to the intent of these amendments, even if there are any technical issues that we might at least be a sympathy for the intent, so that we can get somewhere towards achieving this.
You're probing away there. Probing. I think you're probing. Anyone else wish to speak on this particular amendment? Nobody has indicated. Cabinet Secretary, please.
Thank you. I do appreciate the intent and what Elaine Murray and others are trying to achieve. Section 1 of the bill sets out a number of general principles which are deliberately, both high-level and aspirational, are intended to form the creation of standards of service under Section 2 of the bill. The intention behind including a section on general principles was to set out the underlying aim of the bill and for the justice system as a whole, and ensure a level of consistency when justice agencies are considering how they interact with victims and witnesses. I therefore expect the bodies listed in sections 1 and 2 to consider the needs, rights and wishes of children in the same way I would expect them to consider the needs, rights and wishes of all other victims and witnesses involved in criminal proceedings. If we were to single out child victims and witnesses, as the amendments currently propose, should we not also include victims or persons with a mental or physical disability, older persons, and indeed where would we stop? So whilst I commend and understand Elaine Murray for bringing to the fore the need for organisations to take into consideration the particular requirements of children, I believe that the general principle should be precisely that, general and equally applicable to all groups of victims and witnesses who come into contact with the criminal justice system, albeit refinements may be required for individual categories. So I therefore invite Elaine Murray to withdraw Amendment 55 and not to move Amendments 56 and 57. But I can give her an assurance that we are happy to continue working with the organisations that require to address this so that particular needs of particular sections of society are dealt with.
Elaine, to wind up, please.
Yes, I suppose in my introductory section, I was suggesting that I wasn't convinced this was maybe the best section to put it in. I mean, obviously, it was, I think, important to have it discussed, and there might be other parts of the bill I'm prepared to withdraw at the moment to examine at stage 3 where there might be a more appropriate part of the bill to have a requirement of this type.
Elaine Murray wishes to withdraw. Are you agreed she can withdraw?
Agreed.
Thank you.
And I won't.
We'll have to call it. The Call Amendment 56 in the name of Elaine Murray, already debated Amendment 55. Move or not move? The Call Amendment 57 in the name of Elaine Murray, debated with Amendment 55. Move or not move?
Not move.
Questions that Section 1 be agreed to. Are we all agreed?
Agreed.
Call Amendment 12 in the name of the Cabinet Secretary Group with Amendments 58, 13 to 19, 59, 60 and 61. Cabinet Secretary, please to move Amendment 12 and speak to the other amendments in the group.
My amendments 12 to 19 and 21 all relate to the proposed duty on criminal justice agencies under Section 2 of the bill to set out clear standards of service for victims and witnesses. This proposal has broad support, but at stage 1, the committee and some victim support groups suggested that improvements could be made, particularly in relation to ensuring that there is some consistency in the standards set out by different organisations and that compliance with the standards is monitored. Amendment 18 places a duty on each of the named organisations to consult with all of the other named organisations and with relevant stakeholders before setting their standards of service. I believe that requiring the organisations to consult with each other will ensure a level of consistency in their approach to the standards, while still maintaining the general approach of allowing for organisation-specific standards to be developed, relating to the type of service a particular organisation provides. Furthermore, the duty to consult with those who have an interest in the standards will ensure that organisations such as VSS and Scottish Women's Aid, with the years of invaluable experience from working with victims and witnesses, will have a chance to contribute. Amendment 21 places a duty on the named organisations to publish a report assessing how their standards have been met, how they intend to continue to meet them, any modification made to the standards during the reporting period, and any modification they propose to make during the next year. Best value guidance for public sector bodies already requires organisations to ensure that feedback, including complaints about service standards and failures, is recorded and monitored and feeds into the continuous improvement of services. However, on reflection and in light of representations made at stage 1, I believe that there should be a duty placed on the organisations to publish a report in relation to their standards of service. This reporting will not only ensure that the criminal justice organisations reflect on how they have met the standards during the period of the report, but also to think ahead as to how they intend to meet the standards in the future. Amendment 59 in the name of Elaine Murray is very similar to my amendments 18 and 21, as it also requires the making of reports on an annual basis with an element of consultation. While I obviously support the intention behind this, on balance I consider that my amendments are more appropriate. In particular, I consider that the requirement in my Amendment 21 to set out not only how the organisation has met the standards, but how it intends to continue to meet them over the next reporting period and signal any changes it intends to make, not just in response to any issues raised, but more generally, builds in an element of reflection and continuous improvement, which is vital, and I therefore invite Elaine Murray to consider supporting my amendments and not moving her own. Amendments 12 to 17 and 19 are all technical drafting amendments to aid the clarity of the bill following the insertion of the consultation requirement through Amendment 18. Amendment 58, in the name of Elaine Murray, would put a duty on a person setting and publishing standards under Section 2 insofar as the standards could relate to a child, to do so in such a way that the welfare of the child is of paramount consideration. I welcome Elaine Murray's commitment to child victims and witnesses and agree that organisations should be taking into consideration the specific needs of the group. However, as I've stated in relation to the general principles, if we were to single out child victims and witnesses, should we not include other groups of victims and witnesses? The list could be considerable. I've proposed through Amendment 18 that we place a duty on each of the named organisations to consult with relevant stakeholders before setting their standards of service, and I would expect such stakeholders to include children's organisations where appropriate. I don't therefore believe it's necessary or desirable to single out any particular group of victims and witnesses in this section of the bill, and I move Amendment 12.
Thank you very much. Elaine Murray, please, to speak to Amendment 58 and other amendments in the group.
Thank you, Convener. As the Cabinet Secretary has already said, the purpose of Amendment 58 is to require that when setting and publishing standards in respect to victims and witnesses who are children, this must be done in such a way as the welfare of the child is a paramount consideration. We know that the impact on children of issues to do with criminal proceedings can be extremely traumatising, and that the way in which young people are dealt with, whether it's by police, whether it's by the legal services and so on, are extremely important, and that children often find it very difficult actually to verbalise what's happening to them and what they've experienced. Again, this may not be the most appropriate place to put this, but I think there is somewhere in the bill, there should be somewhere which deals specifically with the issues for children, and it may not be inserting it in the standards of service or in the general principles, but it may be that we actually need to have some amendment on the bill which specifically looks at children and the way we deal with child victims and witnesses. We've also, the Cabinet Secretary also mentioned that my Amendment 59 was very similar to his Amendments 18 and 21. Amendment 59 requires that pupils listed in the section report on their compliance with the standards of service annually, and in preparing that report that the views of victims and witnesses are sought. It also enables those standards to be revised as a consequence of the report and publishes any revision of standards of service to be published. It enables ministers to prescribe the information to be contained in these reports by negative procedure, and this enables compliance with the standards of service to be monitored and revised in the life of experience. Amendment 21, in the name of Cabinet Secretary, is very similar because it also requires the annual publication of reports and requires assessment of whether standards have been met. And I look forward at how they might be met in the following year and any modifications proposed to be made. It also enables ministers to prescribe information by a negative instrument. However, I think the principal difference is that my amendment requires those persons in subsection 2 to consult as far as is practicable with witnesses and victims in preparing the report and in revising the standards. And these should do so as to meet the needs of victims and witnesses. And I think I hear the Cabinet Secretary's plea that I support his Amendment 21. However, actually, I think that provision in my Amendment 59 of consultation with victims and witnesses is important. Amendment 60, again, defines the meaning of child, and it's obviously consequential to Amendment 58.
I think one of your pleas fell on deaf ears there, but we'll find out. Cabinet Secretary to wind up, please.
Well,
Graham, you want to come in there? You didn't indicate. If you would indicate early so that I can move on. Graham.
Yeah, thanks, Convener. I think the evidence that we received in the earlier part of considering this bill from those who were involved in court procedures, the witnesses and victims who were involved in court procedures, certainly impressed me, and I'm sure others, with the feeling of impotence and almost abuse in terms of how they felt, whether right or wrong, as being part of the system. So I know that the Cabinet Secretary is loath to create a special category for children and trying to deal with these situations, as he mentioned in Elaine Murray's Amendment 55. But there's no doubt that the culture within courts, no matter the various pieces of legislation, the cultures in courts as they affect witnesses and victims appears to be quite corrosive in terms of their experience. And perhaps if we would consider at least beginning the shift towards understanding the impact on witnesses, and children are particularly vulnerable in that the world is new to them, and courts will be all the more challenging in their perspective. If you could think of shifting and showing the government's intentions in that regard, it might begin to send a signal which would prevent some of the most awful examples that have been reported over the years, where victims have certainly had a really dreadful time in a public environment of a court. That change, that acceptance of these amendments might begin to signal a change in the approach of those who are in our courts.
Cabinet Secretary.
Well, I think we do accept that we're on a journey, and I put on record my gratitude to the former Lord Advocate Eilish Angelini, who I think kicked all this off, and indeed to the current Lord Advocate Frank Mulholland, who's been expanding it from victims to include witnesses. We do recognise that there were some horrendous situations that shouldn't have arisen. We do hope that they won't arise, and certainly work is underway with judicial studies through the Crown Office and Procurator Fiscal Service to address these matters. I do think, though, that we've got the overall balance right within the bill and with the current amendments here. I think children come in a variety of issues and needs and wants, as we'll be dealing with matters later on in terms of how evidence is given. I think, therefore, what we have to recognise that this is looking at making sure that standards are dealt with by those agencies and bodies that are required to deliver it. I'm happy to reflect upon how we can improve matters, but equally the current positions and the current amendments put forward in my name have been after discussions with organisations including Victim Support Scotland, Scottish Women's Aid, Shakti, etc., who deal not only with adults but also with children, although I do accept that some particular children's charities come specifically and only from that direction. But from the current view of those who are dealing with the challenges of dealing with victims and witnesses, I think their view is that we're required to view it in the totality, although obviously we have to reflect and recognise the needs and wants, because each individual has, in particular circumstances, people may, whatever their age, have physical or mental incapacities that require to be taken on board. There may be particular challenges. That's why we think it has to be looked at the individual, but with victims and witnesses in the totality. So it's making sure that we have the ability to deal specifically with the individual, but having the general guidance right. And I think that's the balance we've provided for.
Thank you, Cabinet Secretary. The question is that Amendment 12 be agreed to. Are we all agreed?
Yes.
Thank you. Call Amendment 58 in the name of Elaine Murray. Already debated with Amendment 12. Elaine, to move or not move?
I will not move that at stage 2. I want to reflect on whether there is a more appropriate part of the bill to bring in provisions for children and maybe bring them back at stage 3. So I will not move that on the
Put the marker down. Thank you. Can I call Amendments 13 to 19, all in the name of the Cabinet Secretary and all previously debated? Can I invite Cabinet Secretary to move Amendments 13 to 19 en bloc?
Moved en bloc.
Does any member object to a single question we put to Amendments 13 to 19? No members objected. The question is that Amendments 13 and 19 are agreed. Are we all agreed? I call Amendment 59 in the name of Elaine Murray. Already debated Amendment 12. Elaine, to move or not move?
I will move this amendment because I believe that because it requires consultation with victims and witnesses, it is preferable to Amendment 21, although no, 21 was part of the way.
Thank you. The question is that Amendment 59 be agreed to. Are we all agreed? Yes. No. There is a division. We are not agreed. Those in favour, please show. Those against, please show. Abstaining? 4 for, 5 against. The amendment is disagreed. Not allowed. Call Amendment 60 in the name of Elaine Murray. Already debated with Amendment 12. Elaine, to move or not move?
Not moved.
Call Amendment 75 in the name of Margaret Mitchell. Already debated with Amendment 74. Margaret, to move or not move?
Not moved.
Call Amendment 76 in the name of Margaret Mitchell. Already debated with Amendment 74. Margaret, to move or not move?
Not moved.
Call Amendment 20 in the name of the Cabinet Secretary. Already debated with Amendment 74. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 20 be agreed to. Are we all agreed? Agreed. The question is that Section 2 be agreed to. Are we all agreed? Agreed. Call Amendment 21 in the name of the Cabinet Secretary. Already debated with Amendment 12. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 21 be agreed to. Are we all agreed? Agreed. Call Amendment 77 in the name of the Cabinet Secretary and a group in its own. Cabinet Secretary, please, to move and speak to this amendment.
Thank you. Article 11 of the EU Victims Directive requires that victims of crime should be able to request a review of a decision not to prosecute, and that the procedure for the review should be determined by national law. I noted with interest the discussion of Article 11 at Stage 1. Stakeholders, including Rape Crisis Scotland and Scottish Women's Aid, questioned why there was not a provision in the bill for a right to request a review of a decision not to prosecute. The Crown Office advised that it was reviewing its current procedure in light of the directive. Having considered this further since Stage 1, I have reached the conclusion that Article 11 should be reflected in the bill, though I believe the detail of how such reviews are carried out is best left to the Lord Advocate. Amendment 77 therefore places an obligation on the Lord Advocate to set and publish the procedural rules for conducting a review of decisions not to prosecute following a request by a victim.
Sorry, did you move that, Cabinet Secretary?
Moved.
Thank you. Anyone else indicating? Margaret and Alison, please.
Just to say I welcome this. I think it's a very positive move forward, and I'll be supporting an amendment.
Alison McGuinness.
I too welcome this movement and this amendment and will support it. I would ask the Cabinet Secretary whether or not he thinks it's fully compliant with the directive in relation to the victim's understanding when they can actually request a review.
Cabinet Secretary.
Well, I believe it is. The devil is always in the detail, and some of this will depend upon clearly what the Lord Advocate brings forward. But obviously, enshrining it in statute does put obligations upon him that would be challengeable in judicial review. But I do believe that it's something where the Crown is willing, and I'm sure discussions either personally or individually by Alison McInnes with the Lord Advocate or as a committee were there will ensure that the balance is struck, ECHR is dealt with, and there are also rights for those who are still aggrieved.
Rod.
Yes. From the point of view of a constituency MSP, it's frequently the case that people write to us regarding decisions not to prosecute. Therefore, I think this move is a very positive step forward.
Can I just remind members to indicate when you want to come in on something? I'm trying to give you a chance, but also to keep us a pace a go here. I take it you no wish to wind up. Do you wish to wind up?
No requirement.
Thank you very much. Question is Amendment 77 be agreed to. Are we all agreed? Call Amendment 78 in the name of Margaret Mitchell and the group of its own. Margaret, please, to move and speak to that amendment.
Thank you, Convener. During Stage 1, the committee heard that communication between justice organisations was not as good as it could be and that this was causing problems. For example, David Ross of the Scottish Police Federation agreed that all partners in the criminal justice system would accept that we have been poor at keeping victims and witnesses informed as to the progress of cases in which they are involved. Victims also said that correspondence was often complex and difficult to understand, particularly when they may already be confused and distressed in the aftermath of a crime. But worse still, David McKenna of Victim Support Scotland told the committee that victims had sometimes to tell their story around 16 times to various agencies, which is clearly unnecessary and unacceptable and can add to the victim's distress. So this amendment seeks to explore what can be done to tackle this problem in the legislation. It would require the Crown and the police to cooperate and to coordinate in the provision of both support and information to victims and witnesses via the creation of a strategic support plan. It would also require the Crown and Police to share information about victims, reducing the need for repetition of stories and to share best practice in relation to victim support. It would also require a single point of contact for all victims and witnesses seeking information so that those involved in the criminal justice system know where they can get help. This single point of contact should be made known to all victims and witnesses and must provide information on the services available to them. And it's the intention of this amendment that properly trained individuals would provide much needed support for victims who are currently not treated with the compassion nor given the time they deserve in all cases. I move this amendment, Convener.
Very much. Any other member wish to? Cabinet Secretary.
Well, I appreciate and welcome the underlying principles behind Margaret Mitchell's Amendment 78, which aims to ensure justice organisations work more closely together in ensuring victims and witnesses have the information and support they need. Indeed, one of the key aims of the Making Justice Work programme set up by this government in 2010 is for justice organisations to work more closely together in delivering system structures and processes that are fit for the 21st century. However, Whilst I agree that justice organisations should work together to support victims and witnesses and to ensure that information is provided effectively, I don't consider that it requires primary legislation. We are already participating in discussions between all justice organisations to explore how they can work more effectively together. An important element of this work is mapping the victim's journey through the criminal justice system and identifying areas in which the organisations involved can offer a more joined-up experience for the victims, some of the matters Margaret Mitchell was referring to. These justice organisations will also be collaborating with each other and with stakeholders in developing standards of service relating to their functions in relation to victims and witnesses. As we discussed in an earlier group, the persons named in Section 2.2, including the Lord Advocate and the Chief Constable of Police Scotland, will be required to consult with each other and with relevant stakeholders prior to publishing their standards. They'll also have to publish a report assessing how their standards have been met and how they intend to meet them in the future, and whether they require any modification made to those standards. And in relation to the proposal for a single point of contact, again, I do not consider that this requires a statutory basis. We are currently looking at the feasibility of establishing an online information hub to provide easier access for victims and witnesses to case-specific information, and are open to other ideas which would improve communication and benefit victims and witnesses. In summary, while I support the broad principles behind Amendment 78, I consider it unnecessary. I think the organisations that have been referred to know, and it's sometimes distressing for them to be putting witnesses through that, and are working to amend it and to change it. And I therefore invite Margaret Mitchell to consider withdrawing her amendment with the basis that these matters are under review, work is ongoing, and the agencies are showing a willingness to go down that route.
Well, I don't usually let somebody. Is it you waving your pen at me, or you wanted to say something? Was that means something? Does it? You want to say something?
I was going to support.
Oh, sorry.
I was going to support Margaret.
You should come in. You should come in earlier on. I'll train them. Someday they will be trained. Margaret, to wind up, please.
I've listened very carefully to what the Cabinet Secretary has said, and while yes, organisations should work, the organisations I've mentioned could cooperate and communicate. The fact of the matter, it isn't happening just now. This amendment focuses very clearly on what should be done. It puts it in statute, and that's a very clear guide for making sure that victims and witnesses are right up there receiving the kind of service they should expect to receive. And although some witnesses, I clearly admit, were split on the idea of having a single point of contact, the Cabinet Secretary has indicated he's not supportive. Diana Greenway, a former Precognition officer, said that she could not stress enough the need for a dedicated and informed support person, case companions, if you like, who have essential experience of the criminal justice process. In essence, this amendment allows a huge improvement for these people who, above all, should really deserve our support, to expect a better experience and better treatment in the courts now, and for that reason I'll be moving it.
No sooner have I mentioned the word train than I get some people. Now, I'm happy to let this develop a little, because I'm a flexible person, as you know, Sandra White, so you want to say something.
Yes, thank you.
Which I'll let you back in if you wish.
Thank you, Convener. Yes. Good morning, Cabinet Secretary. Regarding the online information hub, which you mentioned, would there be further information coming forward on that before the stage 3 of this bill?
Before you do that, I'll let Elaine Murray in. I mustn't show partisanship here, Elaine. It was all going too well, Elaine.
No, I apologise. I did not indicate right at the beginning, but I was listening very carefully to what the Cabinet Secretary was saying in response to Margaret Mitchell before I actually intervened. Of course you were. I am very sympathetic to the principles of Margaret Mitchell's amendment. I think that the issue, and as Margaret herself has said, is that it hasn't been working that well in principle. In practice, even though the principles are there, and this would actually strengthen the requirement. I mean, I appreciate that some witnesses were not happy about the idea of a single point of contact, and presumably Margaret Mitchell's amendment doesn't force somebody to have a single point of contact, but it actually does require that to be done when it's required. So I think this would strengthen the bill if this was included.
Do you want to say anything else backwards, Cabinet Secretary?
With regard to Sandra White's point, all I would say is, I mean, we are looking at a feasibility study at the moment. Whether that will be ready for stage 3, I don't know. A lot of this, some of it will be systemic in terms of the computer systems and linking up, and we're aware of issues there. But as I say, the intention is to look into it. There's a desire to achieve it. And all I can say in response to conveners, I think the glass is most certainly half full. We have come a long way. Each of these organisations have improved, and they're now seeking to work together. That's why I think we should have more trust and faith in them.
May I put it to the vote now? You.
Only closing remark, convener, is that again I refer you to the victim support statement from David McKenna that sometime now today in courts victims and witnesses are having to repeat their story 16 times, which is unacceptable. This amendment would address that situation now, and for that reason I move it, convener.
Thank you. You're pressing it. Yes, thank you. The question is that Amendment 78 be agreed to. Are we all agreed? Yes. There's not an agreement. There's a division. Those in favour, please show. Those against, please show. 4 for, 5 against. That amendment's disagreed. Call Amendment 79 in the name of Alison McInnes and a group on its own. Alison, please to move and speak to that amendment.
Thank you very much, convener. My amendment largely reflects Article 12 of the EU Victim Directive. That directive stipulates that member states must, and I'll quote, facilitate the referral of cases as appropriate to restorative justice services, including through the establishment of procedures or guidelines on the conditions of such referral. End of quotes. It maintains that victims who choose to participate should have access to safe and competent restorative justice services. Amendment 79 would require ministers to make provision for the referral of a victim and the perpetrator of a crime to restorative justice services. It requires them to define when this should occur and set out the procedures for any referral. It also sets out a number of safeguards. Referral would only occur if the victim has consented, and this can be withdrawn at any time. The victim should also be fully informed of how relevant restorative service works and protected from any form of further victimisation or retaliation. I think we know how effective diversion from prosecution projects can be in reducing reoffending, and that's why the amendment also allows for referral to occur before or after sentencing, but only where the perpetrator acknowledges the basic facts of the case. The Government has acknowledged that restorative justice services can be helpful in assisting the victim to overcome their experience. It provides a form of accountability and a forum to receive an apology, and it can enable those who have committed crimes to reflect on their actions, take personal responsibility, appreciate the harm they've caused and start to make amends. And it can prove key to both parties and rehabilitation. Given that the fundamental purposes of the bill is to ensure that Scotland complies with this directive, I'm disappointed that it does not mention restorative justice. It makes no effort to promote the value of it or instil greater confidence in the system or standardise referral procedures. I would move the amendment.
Thank you. I've got Roderick, then Graham, please. Roderick.
I've got some sympathy with Alison's view, but I'm going to say as a committee we didn't actually look at this at stage 1 at all, so it's quite an important area, but I'm not persuaded that having statutory regulations is the right way forward, though I do think we need to pay attention to the issue.
Graham.
Very briefly to say that SACRO have made very strong presentations in support of Alison's approach in this matter, and that it is a whole area of development which we've spoken about regularly over the years, and here's an opportunity actually to do something about it in legislation.
Margaret.
Listen carefully to what the Cabinet Secretary has to say, but it seems to me an omission in the bill, and I'm very sympathetic to Alison McKinsey's amendment.
John, please.
Yeah. I would like to speak in support of it too. I think the balance is correct there, because it's often seen very simplistically as just another avenue of disposal without regard to the victim. And I think there's the appropriate protection there for the victim, and I think it's an important element that should be considered.
Cabinet Secretary.
I fully understand the intention behind the amendment, and Alison McInnes is right to flag it up. Restorative justice is something that I'm supportive of, and indeed it has great benefits in many instances for offenders, and especially for victims. But however, while we've seen that restorative justice processes can be useful in relation to youth justice in particular, I'm not persuaded that the time is right to introduce what is essentially a statutory right to access to such services. detailed consideration would need to be given to the nature and effectiveness of the services to be offered and to the potential costs, which clearly cannot be ignored in the current financial situation. Given the voluntary and case-specific nature of any restorative justice services, I also consider that there are compelling reasons for adopting a more flexible approach than would be possible through a statutory scheme. In particular, it would be difficult to establish definitive circumstances in which referral would be appropriate, which reflect the very personal and specific circumstances of each case. A relatively small number of responses to the consultation were carried out last year. They Making Justice Work for Victims and Witnesses make reference to restorative justice. 2 responses suggested the need to review the role of restorative justice for victims of crime committed by adults. I'd be willing to consider such a review if there was support from victims' organisations, particularly given the provisions around restorative justice services in the recent EU Directive on Victims' Rights. So, in summary, I cannot support Amendment 79 and would invite Alison McInnes to consider withdrawing it, with my assurances that we are open to giving further consideration as to whether the benefits of restorative justice should be more widely reviewed. But at the present moment, there is certainly a difference between what is available in some areas for children and what would be on a statutory requirement for all.
Alison, to wind up, please.
I thank members for their support for this, and I will press this because I think it's important, and I would just, in response to the Cabinet Secretary saying that it's a statutory requirement for all, what the amendment does is it requires the Government to define when this should occur and to set out procedures for referral. So it does allow you to take a stepped approach to that. I do acknowledge that there are many excellent restorative justice services already operating, and I've met with SACRO and I know that they're supportive of this. But I have been concerned for some time that the system is emerging in a very ad hoc fashion, that provision isn't consistent across the country and that best practice isn't always being shared. I believe this amendment will bring the bill into line with the EU directive and help establish appropriate guidelines and procedures, and I would urge members to support this amendment.
Thank you. The question is Amendment 79 be agreed to. Are we all agreed? Agreed. There is not an agreement, there's a division, so those in favour please show. Those against please show. The amendment is agreed. Oh, sorry, I should have read out the result. 5 for, 4 against. Call Amendment 22 in the name of the Cabinet Secretary. Already debate with Amendment 74. Cabinet Secretary to move formally.
Moved.
The question is Amendment 22 be agreed to. Are we all agreed? Please. Call Amendment 23 in the name of the Cabinet Secretary. Already debate with Amendment 74. Cabinet Secretary to move formally.
Moved.
The question is Amendment 23 be agreed to. Are we all agreed? Yes. Call Amendment 24 in the name of the Cabinet Secretary. Group with Amendments 25, 80 and 81. Cabinet Secretary please to move Amendment 24 and speak to the other amendments in the group.
Section 3 of the Bill gives victims and witnesses the right to access certain information about their case on request from the Scottish Court Service, the Crown Office and Procurator Fiscal Service and Police Scotland. This section largely reflects the requirements of Article 6 of the EU Victims Directive. Amendment 24 in my name introduces 2 new paragraphs to Section 3, subsection 6 of the Bill to clarify that victims and witnesses can access information about the location, time and date of any appeal arising from a trial, as well as accessing this information in relation to the trial itself. This coincides with Article 6 of the Directive as read with Recital 31 of the Directive. Amendment 25, also in my name, is a minor drafting amendment to reflect more accurately the wording in Article 6(2) of the Directive by providing that the final decision in a trial and the reasons for that decision should be disclosed to victims and witnesses on request. It also clarifies that the decision in any appeal arising from a trial and the reasons for that decision should be disclosed to victims and witnesses on request. Amendments 80 and 81 in the name of Margaret Mitchell seek to set out specific occasions when information need not be disclosed under Section 3. The Bill reflects the requirements of Article 6 of the EU Directive, which provides that victims should be able to request information on all aspects of the proceedings they are involved in. However, there will inevitably be occasions when releasing some information will not be appropriate, which is acknowledged in the Directive. The Bill as introduced allows for the Police, Crown Office and Procurator and Court Service to exercise their professional discretion in response to the individual circumstances of a case by not attempting to set out specific circumstances when this exemption would apply. I consider these amendments would be unnecessary and that the organisation in question are entirely capable of making decisions without particular circumstances being set out in the face of the Bill. In addition, there is a real risk that the inclusion of Amendments 80 and 81 could result in a breach of the requirements in Article 6 of the EU Victims Directive. There is nothing in Article 6 which would permit a Member State to withhold information from a victim, for example on grounds that it is not in a format which could be given to the victim. The use of the word inappropriate in Section 3(4) of the Bill is designed to capture the situations described in Article 6, subsection 3 and Recital 28 of the Directive, while giving the persons listed in Section 3(5) of the Bill the discretion to decide when a request falls within one of these situations. I move Amendment 24 and urge the Committee to support this and Amendment 25. I invite Margaret Mitchell not to move Amendments 80 and 81.
Thank you very much, Cabinet Secretary. Margaret Mitchell, speak to Amendment 80 and other amendments in the group, please.
Thank you very much, Convener. Section 3 of the Bill places a duty on the Chief Constable, the Scottish Court Service and prosecutors to provide the information relating to criminal investigations to victims and witnesses about their case. Section 3(4) in the Bill allows police and Crown to withhold information requested by victims if they consider it inappropriate to release the information. This exemption may be necessary in a range of circumstances, and withholding this information may be in the interests of the victim or, more widely, in the interests of justice. However, the Bill doesn't provide any guidance on what is meant by the term inappropriate, and witnesses, including the Law Society of Scotland and Scotland's Commissioner for Children and Young People, told the committee that guidance was needed. This amendment would make it clear in what range of circumstances information requested can be refused. This would include cases where disclosing the information would breach any other legislation, if it would be contempt of court, if it would prejudice justice, if it would cause distress to the requester, or if information is not available in a transferable format, or if information can be easily obtained elsewhere. So the reason for tabling this amendment, I don't accept it as so prescriptive it would breach Article 6, is an attempt to tease out what exactly the Scottish Government means by inappropriate. The type of information we're talking about here includes information on a decision to end a criminal investigation, a decision not to proceed to trial, the date and time of a trial, the nature of charges, the stage of criminal proceedings, and the final disposal, all very important stages. This amendment lists some of the reasons why this type of information should not be disclosed to victims. However, in the vast majority of cases, there's no reason why this information should not be disclosed, and I'm sure this will be the case under the legislation. But in the interests of clarity, clear guidance, either on the face of the bill or elsewhere, should point towards the types of cases in which information should not be disclosed. Amendment 81 is consequential on Amendment 80 on the disclosure of the information. I move Amendment 80. I don't need to move it. No. Can I speak to Amendment 24 and 25, which I think, again, are improvements?
Yes, of course you can speak to any other amendments in the group.
Yeah, supportive of the content of both of these amendments.
Alison McInnes.
Just to say that I support Margaret Mitchell's Amendment 80. I think it would prevent people hiding behind just one word and say that we're not disclosing information because it's inappropriate. It encourages people to be open, and I think we should welcome this amendment.
Right, Cabinet Secretary, please, to wind up.
Well, I think the whole intention of Amendments 24 and 25 is to make sure and make it clear that organisations should, wherever, seek to provide that. I think trying to provide precise clarification where circumstances would preclude it is very, very difficult because they're case specific. I think John Finney gave the committee some examples from his experience as a police officer. Equally, we have the suggestion that it could relate to where there's an investigation into the individual themselves with regard to fraudulent crimes related to the case. I think it's very difficult to specify these matters. What we have to do is to have a general presumption and equally allow some flexibility for organisations. The difficulty with going down Margaret Mitchell's route is as soon as you specify matters, if they're not covered by those particular matters, then there can be great difficulties for the organisations involved. And I think we have to have some trust and faith in organisations who have a statutory duty and are looking to do the right thing, but have to have some flexibility to deal with circumstances that we probably cannot envisage at the present moment that may arise.
The question is Amendment 24. Yes, you may. Yes, you may reply.
I think transparency is absolutely fundamental. This amendment provides transparency into what range of circumstances, not specifics, as the Cabinet Secretary has tried to whittle it down to, but a range of circumstances which it would be inappropriate. And on that basis, Convener, I'll be moving it.
Well, before you get to that, I just want you to answer that. I'm
think
allowing flexibility
where Margaret Mitchell
here.
is taking us...
Hang on a wee minute, I hadn't finished. I'm finished now, right?
Where Margaret Mitchell is taking us would be presumably to open up the opportunity for judicial review, for somebody to have it disclosed that perhaps there's an ongoing investigation, or indeed the circumstances that would be quite distressing for other relatives. So, as I say, some of this, as I say, is about ensuring that there is the statutory guidance given, that organisations are coming from it from that perspective. But I think as soon as you're specific, then by nature some matters are not referred to are excluded and causing difficulties, and equally you're open to challenge, which, as I say, may cause significant problems and greater distress.
The reason I let Cabinet Secretary back in again is because in terms of process, the person who moves the First Amendment in a group, some winds up at the end. But I'm quite pleased to let other people come back in. That's just the way it operates. If you're moving something in the middle of a group and you're not the first mover in it, you really, in general process, are not the person who winds up at the end. But I'm happy to be flexible about it, obviously, where there's issues to be clarified. I think
there's an important point that the Cabinet Secretary has raised in giving him the right of reply.
No, I haven't given him the right of reply. The mover of a group, any mover of a group, is the person who winds up. Okay. Right? So, but that's the usual process, just to remind members. So if you were the first mover of a group, notwithstanding there was another one in the middle of it, another very important amendment in the middle of it, you would have the right of final summing up. That's just the way the procedure operates. But I'm happy to let someone back in who's got an amendment in the middle of a group. Have I made myself clear? Yeah. You're looking puzzled, John. Have I explained that?
No, you're very clear.
I'm very clear. I do like you. Right. So that's just why I'm explaining it, so that if you're the first mover, if you're the mover amendment in a group, you have the final say. Okay? Just for clarification. Right, I've lost my place. Now, I haven't, not really. Question is Amendment 24 be agreed to. Are we all agreed? Call Amendment 25 in the name of the Cabinet Secretary. Already debated with Amendment 24. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 25 be agreed to. Are we all agreed? Yes. I call Amendment 80 in the name of Margaret Mitchell. Already debated with Amendment 24. Margaret, to move or not move?
Moved.
The question is Amendment 80 be agreed to. Are we all agreed? No. There is not agreement. There's a division. Those in favour, please show. Those against, please show. There's 4, 7 against. That amendment is disagreed. I call Amendment 81 in the name of Margaret Mitchell. Already debated with Amendment 24. Margaret, to move or not move?
Moved.
The question is that Amendment 81 be agreed to. Are we all agreed? Do you want to?
It's consequential, so it didn't really matter.
Well, do you want to change? You've already moved it, so I think I have to stick with
that's
it.
Fine.
Yes,
that's fine.
So there will be a division. Those in favour of Amendment 81, please show. Those against, please show. There we are. 1 for, 8 against. That is disagreed. I call Amendment 26 in the name of the Cabinet Secretary. Already debated with Amendment 74. Cabinet Secretary to move formally.
Moved. The
question is that Amendment 26 be agreed to. Are we all agreed? The question is that Section 3 be agreed to. Are we all agreed? I call Amendment 61 in the name of Alison McInnes, group with Amendment 62. Can I point out, if Amendment 61 is agreed to, I cannot call Amendment 62. There's preemption. Alison McInnes, please, to move Amendment 61 and speak to both amendments in the group.
Thank you very much, Convener. And let me start by saying the fact that the bill will place the existing guidance on joint investigative interviews on a statutory basis is indeed welcome. However, my Amendment 61 would require constables and social workers to comply with the guidance issued by the Scottish Ministers when carrying out interviews with children, anyone under the age of 18, in relation to criminal proceedings. I'm concerned that the current provision in the bill that those persons should have regard to the guidance will not adequately ensure that it is consistently adhered to. It rather gives the impression that it matters little if they do not follow it. Now, John Finney's amendment builds on the Government's proposals. The convener has just noted that my amendment preempts it, but if my amendment is not passed, I would support John's minor strengthening of it. I do share Children First's concern that guidance of this nature should only be deviated from in exceptional circumstances, and it strikes me that such circumstances, those cases or instances where it's deemed permissible to depart from the rules, could be accommodated within the guidance, and I move Amendment 61.
Thank you very much. John, please, to speak to Amendment 62 and other amendments in the group.
Thank you, Convener. The Convention of Joint Investigations has had some good experiences for children as a result of primarily the training. What remains the case is that they're sometimes perceived as being different interests, and if we have the interests of the child at the foremost, then this guidance should have primacy. These competing interests will sometimes the pressures on staffing and the pressures on overtime budgets, for instance, could begin to impact and geographically, particularly more so in rural areas. So I think it's very important that we have consistency, and the examples which will be known to many of the different approaches taken by people who have received this training and those who haven't, and the different outcomes it's achieved. I think it's very important that there's the significance given to this training, and I clearly won't dissent too much from what my colleague Alison McInnes says either.
Thank you. Elaine.
Yes, I support both the amendments, although they obviously one precludes the other. I think that the general thrust of both is correct. The only thing I would say possibly in support of 62 in John Finney's name rather than 61 is that there is a bit more flexibility in that amendment, in that it is not that Alison McInnes's amendment would appear to insist that you comply in every single circumstance, whereas John Finney's is actually a bit more flexible and allows maybe that exceptional circumstance when it's not possible to be accommodated.
John, yes, do you want to come back in?
Well, thank you for being flexible and allowing me to come back in. Because
you've got flexible amendments,
yes,
apparently.
Well, the reality of the situation is that flexibility can be used very positively and pragmatically if the interests of the child are put to the fore, or could be used if there's an insistence. It does build in that flexibility around staffing deployment for the police in particular, I think, because I don't think there is a similar issue with the social work, having people competently trained involved in joint investigative interviews.
Cabinet Secretary.
The guidance on interviewing child witnesses in Scotland currently sets out principles of best practice for police and social workers undertaking joint investigative interviews, and aims to make the process more child-focused and enhance the quality of such interviews. And the intention of Section 4 of the Bill is to put this guidance on a statutory footing and to require police and social workers to have regard to it when undertaking such interviews. Amendment 61, in the name of Alison McInnes, would have the effect of requiring the police and social workers to comply with, rather than simply have regard to, the guidance. In placing an obligation on the police and social workers to comply with the guidance, we would effectively take away any discretion on behalf of these professionals to make decisions based on the individual circumstances of a case, no matter how exceptional those circumstances may prove. Furthermore, a requirement to comply with the guidance, rather than have regard to it, may force the police or social work into a position where, in order to do the sensible thing in the circumstances of the interview, they must breach their statutory obligation, as no departure from the guidance, however reasonable, would be permitted by this amendment. The amendment would also have the effect of empowering the Scottish Ministers to effectively issue instructions to the police and social workers to operate in a certain way without any requirement for parliamentary scrutiny of those instructions. The guidance issued under Section 4 of the Bill does not require to be laid before Parliament. Clearly, the use of the term guidance would be misleading if it were compulsory. I also welcome John Finney's recognition of the importance of this guidance. However, while I agree that ensuring that regard is had to the guidance is vital, I consider the reference to due regard to be unnecessary. Departing from the duty that is currently in the bill, which is commonly used, might also create some uncertainty about how the guidance would apply in different circumstances. I believe the wording in the bill as introduced strikes the appropriate balance between putting this important guidance on a statutory footing whilst not removing the very discretion that may prove essential in protecting the best interests of the child at a particular time or interview. I therefore cannot support Amendments 61 and 62.
Alison, to wind up, please.
We've heard already this morning, particularly from Elaine Murray, about how the police or social workers conduct interviews with children is really key. And typically at the start of the investigation process, we need to ensure that children feel comfortable and confident when telling their often traumatic experiences. And conducting the interview in a manner that coheres with the child's best interests will ultimately lead to a better quality of evidence. But I have listened to what the Cabinet Secretary has said about discretion, and I would not wish to fetter the professionals' ability to respond flexibly to that particular child's needs. And therefore, on that basis, I will currently withdraw my amendment. But I do think that John Finney's amendment, which just gives a little bit more clout to it, I would still support.
Alice McGuinness seeks to withdraw that amendment. Are you agreed?
Agreed.
I call Amendment 62 in the name of John Finney, already debated from Amendment 61. John, to move or not move?
To move. Convener.
The question is that Amendment 62 be agreed to. Are we agreed?
Agreed.
There is not an agreement. There's a division. Those in favour, please show. Those against, please show. Those in favour 5, those against 4. That amendment is agreed to. The question is that Section 4 be agreed to. Are we all agreed?
Agreed.
The question is that Section 5 be agreed to. Are we all agreed?
Agreed.
Good. Shall I slow down for you all? You're not on your Weetabix and porridge. Can I call Amendment 27 in the name of the Cabinet Secretary and a group in its own Cabinet Secretary to move and speak to the amendment, please? Amendment 27.
Yes, Section 5 of the bill contains provisions allowing victims of certain offences to choose the gender of the officer interviewing them. At Stage 1, stakeholders welcomed these provisions, but also called for this right to be extended to enable such victims to choose the gender of the person carrying out their forensic medical examination. In my response to the committee's Stage 1 report, I made a commitment to consider this suggestion further. As I said when giving evidence at Stage 1, this is not just about legislation, but about ensuring that things happen in practice. All those who deal with such matters, whether it be police, Procurator Fiscal Service or the Health Service, recognise that the process is traumatic and anything that can be done to reduce the distress for the victim is very important. We want to ensure that there is flexibility to deal with such situations as they arise, regardless of time of day or geographical location, and that if the victim says that they want a doctor of a specific gender, we should seek to provide that doctor. There are clearly wider justice and health implications in terms of delivering a service responsive to the needs of victims of sexual offences. This cannot be achieved through legislation alone. Crucial discussions are already underway between Police Scotland and NHS Scotland to ensure that appropriate guidance and support is available to both those responsible for carrying out the forensic examination and for the victims of sexual offences. It's also clear that the development of the relevant workforce of the future must be responsive to the requirements of these victims. Amendment 27 will underpin this ongoing work. It will ensure that the police inform alleged victims of sexual offences that they may request a forensic medical examiner of a specified gender. It will also ensure that the request is relayed to the doctor who is to conduct the forensic medical examination. To take into account the evolving remit of healthcare professionals, I proposed a power to amend the reference to a registered medical practitioner if it were required to reflect future practice. I acknowledge that meeting the needs of victims of sexual offences clearly requires more work and that this amendment alone is not a complete solution to the issues raised. I believe, however, that it is a vital first step in ensuring the views of victims are sought and efforts are made to meet such requests, and that it will act as a driver for a more comprehensive change. I move Amendment 27.
Margaret, you want to make
just to say I'm very supportive of this again. It's a positive move forward for victims.
Sandra?
To echo Margaret Mitchell's comments, I'm very supportive of it, and I welcome from the Cabinet Secretary this amendment. I think it is certainly a step forward, and I thank all the groups who came and gave evidence to the committee requesting this type of amendment or move forward within the justice system.
Graham?
Yes, again, to agree with earlier statements in the matter, it's a very sensitive issue about access to practitioners at a time of great stress, and I think that the Cabinet Secretary's amendment strikes a right balance at this stage in terms of responsibilities and responses.
I take it you don't wish to wind up, Cabinet Secretary. Question is that Amendment 27 be agreed to. Are we all agreed? Agreed. I call Amendment 82 in the name of Graham Pearson, group with Amendments 83 and 85. Graham, please, to move Amendment 82 and speak to the other amendments in the group.
Thank you, Convener. I do move Amendment 82 and indicate that this amendment deals with a very sensitive issue for the courts, and one which has caused a great deal of controversy over a number of years. It relates to evidence in relation to sexual offences and the ability or otherwise of the courts to review a victim's previous health record. Amendment 82 seeks to empower Scottish ministers by means of regulation to make provisions for circumstances when information relating to the physical or mental health of a person who is or appears to be a victim of offence of a type mentioned in subsection 3 can be disclosed in relation to criminal investigations or criminal procedures. The regulations must make provision in particular for the circumstances when it may be appropriate to seek disclosure of such information, the process by which decisions to disclose such information can be made, and subject to paragraph D, the need to obtain the free and informed consent of the victim, and in circumstances where it may be appropriate to disclose such information without the consent of the victim, and the nature of the support that must be made available to the victim where disclosure of such information is sought. Evidence from Rape Crisis and other women's aid groups made it very clear that within the courts, victims do feel a further level of victimisation when, in terms of their view and evidence, past history of medical conditions are exposed within the public domain of a court. In inappropriate circumstances, a victim feels that that disclosure not only breaches their rights of confidentiality, but exposes them to a great deal of embarrassment and further victimisation. There have been a number of cases where such disclosures have occurred, and it's caused a great deal of public angst in the way in which it has been dealt with. And it would appear that currently it's left to individual judges to decide whether or not such information should be shared in the public domain as part of the criminal process. The amendment seeks to ensure that the government can offer some guidance in making these decisions, and guidance which would be helpful in delivering a proper process of deciding the law and circumstances and the justice in particular cases without further abusing a victim who becomes the target of intrusive questioning by defence agents investigating circumstances which sometimes are historical in character, and when heard in the open court can be deemed by many who witness these interrogations inappropriate in the extreme. So I would encourage the Cabinet Secretary to look kindly on the amendments, which I think would be welcome by victims who are particularly affected by sexual offences and have suffered over many years in our courts. And no matter the previous guidance which have been offered to courts about how such circumstances should be managed, we still have members of our communities badly affected by such interrogations in the public domain. If I can comment on Amendment 83.
Of course you can.
Margaret Mitchell seeks to deal with a similar set of circumstances, I presume, and would seek to introduce the idea that legal advice would be made available to victims in such circumstances. And I presume from the detail that we've received that legal advice would seek to offer a protection in similar domain. I find it a challenge to conceive of a third member within the court process whose specific duty would be to protect a victim in such circumstances. I would presume that the Cabinet Secretary would be concerned about the financial implications of such an arrangement, and I think that I should be responsible in acknowledging that financial implication and dealing with it. And I would have hoped that our Scottish courts, in administering justice, should, if properly guided, ensure between the Crown Office and Procurator Fiscal Service and a properly guided process with the advocates who appear in court should be able to deliver on our behalf without the need for an additional member of the legal profession to be there. And I think that a trial process would become enormously complicated by such a member of the legal process being within the court and looking towards the needs and requirements of a victim solely. And for that reason, I find Amendment 83 a challenge, and I'm not minded to support it.
Margaret Mitchell, please, to speak to Amendment 83 and the other amendments in the group.
Thank you, Convener. The concerns surrounding the use of sexual history and the character evidence in sexual trials are not new and have stretched back for far too many years. Section 274 and 275 of the Criminal Procedure Scotland Act 1995 allows the defence to make application to use the sexual history and character of the complainer in sexual offence trials. Legislation designed to restrict the use of this type of evidence was passed in 2002, meaning it is now not necessary for a written application to be submitted in advance of the preliminary trial. The court can only admit such evidence where it is satisfied that it is relevant to whether the accused is guilty of the offence and the value of the evidence is likely to outweigh any risk of prejudice. An evaluation commissioned by the Scottish Government and published in 2007 found that far from tightening the use of sexual history and character evidence, legislation introduced by the Scottish Government in 2002 had actually led to an increase in the use of this type of evidence. The key findings of the research made for very concerning reading. 72% of trials featured an application to introduce sexual history or character evidence, and only 7% of these applications were refused. Concerns about the use of this evidence relate to its potential to be highly prejudicial, particularly in light of pre-existing attitudes in some jury members. It can also, without doubt, be extremely distressing for victims and can actively deter victims from reporting crimes to the police. The type of information requested in sexual history is often irrelevant to the case. 24% of the evidence sought relates to the general character of the complainer, including previous and long-resolved mental health issues. Amendments 83 and 85 were suggested by and have the support of Rape Crisis Scotland. Their experience is that the use of this type of information is causing distress to victims, and the relevancy of the evidence is not being routinely challenged by the Crown. It appears that in the vast majority of cases, complainants consent to their records being recovered, but they do not feel this consent is given freely, because the likely alternative is the possibility of the prosecution being dropped or a warrant sought for the information. Part of the problem is that we do not have up-to-date information on the use of Section 274 and 275 applications. The Crown does not currently record the use of applications, and therefore we only have the 2007 figure to go by. These amendments would have two effects. Amendment 83 would require independent legal advice to be provided by victims of sexual offences, for victims of sexual offences, when the information is requested from the Crown, Defence or the police. The legal advice would provide victims with their rights, explicitly making them aware that they are able to refuse such requests. Amendment 85 would provide independent legal advice at a preliminary hearing where the Crown and the Defence can lodge an application to use complainers' sexual history and character. It's hoped that this legal advice would be provided largely on a pro bono basis and at little cost, but it may be that legal aid requires to be extended to cover this type of legal representation. Independent legal advice is a routine entitlement across European jurisdictions such as France, Belgium, Austria, Finland, Greece, Spain and Sweden. In Ireland, which is an adversarial legal system, sexual offence complainers have a right to independent legal representation if an application is made to a judge by the defence to introduce sexual history evidence. Independent legal advice could be implemented in a phased way, and my amendment leaves it open for a pilot to be carried out. These changes are a practical way to help rape victims avoid unnecessary distress during the court process. Currently, they have little way to challenge the legality of using their private information in court, and it appears the Crown is not robust enough in challenging Section 274 and 275 applications. But perhaps more importantly, if this type of evidence is being routinely used, then there is a real concern that medical records and sensitive information is being used as a way to discredit witnesses and play into the prejudices and myths that we know prevail around sexual offences. Turning to Amendment 82, in the name of Graham Pearson, whilst I appreciate that he too seeks to address the same issue, but in a slightly different way. It would require Scottish ministers to make rules on when information relating to physical or mental health of a victim can be disclosed in court. The issue is that these rules are already legislated for. The problem is they don't seem to be robustly followed, and inappropriate information continues to be used in court. Amendment 82 does not establish independent legal representation for victims, and I should say that these two amendments have the broad support of the Faculty of Advocates.
Elaine. No, you're not moving it. No. Elaine, followed by Roderick, please.
I'm very sympathetic to the policy intention of all these amendments. I think it's a very important issue in terms of, we know the damage that can be done to some victims by being forced to disclose aspects of their lives which are not really relevant to the case and can cause them extreme distress. However, I do have some concerns about Margaret Mitchell's amendments 83 and 85, and I would tend to support Graham Pearson's amendment in that it actually, again, is more flexible. It again allows ministers to make regulations. This is actually compelling ministers to make new regulations and regulations which come before the committee by affirmative procedure. So I think I prefer that approach. On Margaret Mitchell's amendments, I think there is an issue about the relation between that particular legal representation and the legal representation which is already in court. And the other thing which worried me, now it may only worry me because I'm a novice to the committee and I'm not from a legal background, but the requirements in 83 subsection 5 and 85 subsection 5C that the complainer is automatically entitled to legal aid seems to me to run contrary to the circumstances in which legal aid is normally available, which is actually income dependent. So I seem to make a particular exception in those cases, which I would be a little bit concerned about if that is the case, or if that's maybe that's a misunderstanding on my point. But if that is the case,
so. You're too clever for that.
so I have a little bit of a concern about that provision being introduced in this way.
Roderick.
Thank you, Convener. Perhaps I should just refer to my register of interest as a member of the Faculty of Advocates. I've got sympathy with Margaret Mitchell's Amendment 85. Specifically, first of all, on the legal aid point, though, I think I rather concur with what Elaine has actually said on that. It doesn't seem to me appropriate for that provision to be in the amendment at this stage. But if we are to make some progress in dealing with the widespread attitude from people that they look at the Crown as representing the public interest and they ask the question, and who's representing my interest? Who's my lawyer? And it's precisely on these kind of applications that these issues arise. I think it is a real issue. Perhaps it was flagged up by us when Murdo MacLeod of the Faculty of Advocates gave evidence and we didn't actually explore it in detail. It would be breaking substantial new ground. I'm not entirely sure what discussions the government's had with the Faculty of Advocates as opposed to Rape Crisis Scotland since stage one. Certainly, I think the onus was on the Faculty of Advocates perhaps to convey their thoughts to the government. That seemed to be the impression from the evidence session in May. Whilst I therefore have reservations about the amendment itself, I think this is an issue that shouldn't go away, and whilst I will support or oppose Margaret Mitchell's amendment today, I think the issue needs wider attention than we've given it so far.
I'm actually going to say something as well here, which is a change. I actually, while hugely sympathetic to the difficulties in giving evidence in court for lots of people, but in particular sexual offences and so on, I'm pleased that both of these amendments say, use the term a person who is or appears to be the victim, because there's this difficulty always of using the term victim in court proceedings when, of course, we have the presumption of innocence and the onus is on the Crown to establish guilt. So it's a very difficult area to get definitions right. With regard to Margaret Mitchell's amendment, I think I had concerns immediately when you said introduce pilots. Because if you were to pilot something, then you are changing the rules of justice, as it were, the access to justice in different parts. Because then you'd be having some people being giving independent advice about inquiries into their medical and sexual health background, and others not, while trials were going on. And the second thing was the use of the term pro bono, which would again introduce, perhaps, if there wasn't legal aid available, a different type of access to independent legal advice for different people. So I think these are practical comments to make in relation to your submission rather than what you have in the amendment. I just thought I'd make that comment because I think I've made this before the Cabinet Secretary as well, the huge difficulty about the term victim and appears to be the victim. And it's this difficult balance, I think, in getting the legislation right to make sure it's fair to victims, but it's also fair in the interests of the accused. Cabinet Secretary.
Thank you. Well, I think we've all got a great deal of sympathy with the intention behind each and every one of these amendments, but with regard to Margaret Mitchell's amendment, I would echo the comments I think already made by Graham Pearson and others, but let me deal with them specifically because there are difficulties. First of all, with regard to Amendment 82, making regulations governing the application for, granting and circumstances of disclosure of information relating to a victim's physical or mental health would be a major departure from current practice. Mr Pearson might draw an analogy with the regime in sections 274, 275, 275A and 275B of the Criminal Procedure Scotland Act 1995 in respect of evidence of a complainer's sexual history. However, this proposal goes further than that regime in two important respects. The first is that the restrictions on rehearsing a complainer's sexual history in a trial relating to sexual offences are of obvious and immediate relevance. The current proposal greatly extends both the categories of offence in which restrictions would be imposed and the kind of evidence which could be denied. Aside from the reluctance we should have to withhold evidence from a jury, the link between sexual offences and sexual history is wholly absent in this proposal. If evidence of a victim's mental or physical health is to be restricted in this broad category of offences, why not in others? Why should evidence of a victim's state of health be restricted in a stalking case, but not in a case of assault? The other major difference with the existing regime in the 1995 Act is that the proposal would oblige the government to define in legislation matters which the court is currently free to decide. For example, it includes the government deciding whether a court may even allow an application to be made to it. this government has promoted the independence of the judiciary, setting this out in statute. It takes the view that decisions about proceedings before them are best left to the courts themselves. We would be very reluctant to take on the function of making courts procedural decisions for them. These are best made in the circumstances of each case by experienced personnel who have heard all the proceedings. We are also conscious that restricting the availability of evidence by law, irrespective of any circumstances in which a case may turn, is a matter which has clear human rights implications. Turning to Amendments 83 and 85, these too would result in a major innovation in our law. There are currently no rights for victims to have independent legal representation in criminal proceedings. Again, I have to question taking such a step at all, but particularly in the case of the proposed restricted group of victims. It would be a tricky task to defend a situation in which the victim of assault, left in a wheelchair by her attacker, was not deserving of legal representation, but the victim of a sexual offence was. The assault parallel is an apposite one, since, for example, in the case of a self-defence plea, evidence about the victim's state of health or previous conduct may very well be relevant. It is clear, then, that the drastic innovation the amendments propose to make is one whose scope is difficult to defend. Inevitably, they will lead to demand for similar rights for other victims, possibly to the great detriment of the availability of evidence and thus the fairness of trials. Finally, in relation to the proposal in Amendment 83 that alleged victims be given an opportunity to seek legal advice or representation when information is being sought before the criminal proceedings have been raised, for example by Crown Office of the Police, it is unclear what additional benefit this would bring. Clearly, if information is being sought, then the reason for this should be clearly explained. But this seems a matter which could be dealt with on a practical basis, rather than requiring advice from a solicitor. And I understand that the Crown Office in particular already has comprehensive guidance in place to ensure that victims are given a full explanation of exactly why any sensitive information is being asked for. Furthermore, in the event that legal advice is required, current legal aid legislation already makes this available to victims and witnesses through advice and assistance subject to the usual statutory tests. As I say, I do appreciate the intention behind these amendments and agree that we should do all we can to reduce the distress of alleged victims in such cases. I discussed this matter with Rape Crisis Scotland, who I know spoke in favour of similar proposals at Stage 1 just last month. As I said then, I think these proposals are a step too far, but I am more than willing to consider the underlying concern raised, to work with Rape Crisis, the Crown Office and Procurator Fiscal Service and others to explore what more can be done. With regard to the specific point raised by Rod Campbell, we have met just recently with Rape Crisis Scotland. My understanding is that the Crown Office have agreed to gather more information in Section 275 and will be discussing with Rape Crisis Scotland. The Faculty of Advocates has not been in further touch since they indicated their report for support for Rape Crisis Scotland. But I do fall back, and I think, on the position taken by Graham Pearson, that this would be a fundamental review and change in the basis of how we conduct criminal trials, and it's a matter that I think would cause great difficulties for those presiding.
Graham will be summing up because he moved it, but if you want to come back and say something before I take Graham to wind up. Yes, Margaret.
I can perhaps gently remind the Cabinet Secretary that the greatest threat to the fairness of trials is the Cabinet Secretary's current endorsement of the proposal to abolish corroboration. And I can't say... Not relevant to the bill. I will rule that out of order. It's not relevant to the bill. Well, the Cabinet Secretary did say that this would prejudice a fair trial, and I can't say that the main thrust of his comment fills me with anything other than dismay. It's a green light for business as usual, and the kind of sexual history and irrelevant information that is being used day in, day out to discredit witnesses would continue. However, I have reflected on some of the other comments, not least the Faculty of Advocates, who have suggested some things that could improve this amendment. It's important that we get this right, so I will be bringing it back in Stage 3, reflecting on the comments in the hope we can persuade the Chamber to do the right thing.
Graham Pearson, please, to wind up.
Thank you, Convener. The Cabinet Secretary has made a number of comments this morning in relation to these proposals. He properly identifies that what we are talking about here in terms of victims is the use of sensitive information which is highly personal to the victim, alleged victim, in a public domain. The Cabinet Secretary suggests that decisions in relation to these issues are best left to the courts themselves, and that they should be decided by those who hear the whole trial. That is another problem in the current situation. It's acknowledged even by the Cabinet Secretary and others around the table here that we have a problem, and it's a problem which has pertained for decades, that victims are going into the court and being exposed in the public domain in relation to highly sensitive personal information which can then not be switched off and forgotten about. And we cannot allow this to continue. The Cabinet Secretary says that in focusing solely on sex-related crimes, it creates a new category and sets a precedent, and it could also apply to assaults and so forth. The truth is, we don't appear to have a problem in those trials where assaults are alleged in other cases. There is something which pertains in the public mind, which creates a mystery surrounding this particular category of crime, which seems to then allow the courts and those who serve the courts to delve into the background of victims to an extent which I think goes beyond that which is necessary. And as has been alluded to by Margaret Mitchell, in 72% of trials, this whole issue has become central to the development of cases within the court, and that's after legislation that was put in place in 2002. Again, the Cabinet Secretary is correct in acknowledging that Rape Crisis Scotland and indeed other women's groups have focused on this issue repeatedly year after year. I think that victims look to the Parliament to protect them in putting together a set of legislation which does as best as humanly possible to guard their requirements whilst at the same time delivering due process and justice in a trial situation. Roderick Campbell has acknowledged there's a real issue here. Margaret Mitchell has outlined in great detail the evidence which lies behind the need for such an amendment. The Cabinet Secretary has indicated that he's very sympathetic to the problems that we allude to here, and he's willing to have discussions with all the partners who deal with these issues. I really do think the time is now for us to show a real commitment to dealing with an issue which has caused enormous embarrassment in public court, has been reported on repeatedly in the media, where, and it largely as women, one has to acknowledge this, and sometimes children who are exposed in our public courts and then have to live with that exposure in their own communities day after day, month after month, year after year, and we all walk away from it and feel that we've been part of a process. He's got a real opportunity now. I would be happy to see some discussion about the nature of the amendment, but I do hope that the committee will support Amendment 82 and allow us to break what has previously been an injustice suffered by victims in our courts, and we've condoned up till now.
Pressing the amendment.
I am indeed.
Thank you very much. The question is that Amendment 82 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will division. Those in favour, please show. Those against, please show. Abstentions? Those for 3, those against 4, abstentions 2. That amendment is disagreed. Call Amendment 83 in the name of Margaret Mitchell. Ready to debate Amendment 82. Margaret, to move or not move?
Not moved, Convener.
Thank you. I call Amendment 28 in the name of the Cabinet Secretary Group with Amendments 52 and 53. Cabinet Secretary to move Amendment 28 to speak to the other amendments in the group, please.
Amendment 28 is a minor drafting amendment to Section 6 of the Bill to make it clear that the subparagraphs in the new Section 211C of the Criminal Procedure Scotland Act 1995 are intended as alternatives. Amendments 52 and 53 are minor drafting amendments to Sections 23 and 25 of the Bill to correct the format of the references to the Prisons Scotland Act 1989 and our amendments to Section 16 of and of our addition of Section 17A to the Criminal Justice Scotland Act 2003. I move Amendment 28.
Thank you very much. Any other members wishing to speak? I take it you don't wish to wind up, Cabinet Secretary. Question is Amendment 28 be agreed to. Are we all agreed? Question is that Section 6 be agreed to. Are we all agreed? Question is that Sections 7 and 8 be agreed to. Are we all agreed? Call Amendment 63 in the name of Alison McInnes, group with Amendments 64, 65 and 67. Alison, please to move Amendment 63 and speak to the other amendments in the group.
Members will recall that the Victims Organisation Collaboration Forum Scotland, a group comprising 12 victim support organisations, wrote to the Justice Committee on the 18th of June regarding the proposal to allow objections to special measures. It described their shared deep concern and united opposition to the Scottish Government's plans. Indeed, they argued that it would undermine all the other provisions and rights contained in the bill. That's a truly damning verdict. So my Amendment 63 would remove the proposed right of any party to a criminal proceeding to lodge an objection notice to the use of standard special measures, those protections which children and vulnerable witnesses are entitled to by law at the present time. A live TV link, a screen or a supporter can empower these individuals to give their best evidence. Removing this entitlement would result in an increase in the number of vulnerable witnesses having to appear in the courtroom. And the objection process, even if unsuccessful, will only serve to prolong the process, increase the apprehension about giving evidence and severely dent their confidence in the system. It will make their experience worse, and we should not ask vulnerable witnesses and their legal representatives to justify the use of standard special measures or risk denying them their rights. I note that it has also been proposed to delete Section 9 entirely. My amendment differs from that of Elaine Murray's because it still affords both parties the right to lodge an objection notice to an application for further special measures for children and deemed vulnerable witnesses. I believe that if additional special measures are applied for, then the accused should have the right to question why these are necessary, given the considerable list of standard measures. As drafted, this section of the bill would clearly erode the existing rights of children and deemed vulnerable witnesses, not enhance them. The committee, you will remember, that we raised significant concerns about this section at stage 1, and I hope that the committee will agree with me that standard special measures for these groups must always be deemed appropriate, and I move Amendment 63.
Thank you very much, Alison. Cabinet Secretary to speak to Amendment 64 and the other amendments in the group, please.
I fully support Alison McInnes' Amendment 63 and consider it addresses the concerns expressed during Stage 1 by the Committee, the Crown Office and various victim support organisations. I should emphasise that the intention behind the original provisions was not to complicate proceedings or to undermine the support available to vulnerable witnesses, but rather to ensure compatibility with ECHR and give the Court the flexibility and discretion to consider any legitimate concerns raised by any party to the proceedings. As indicated to the committee, the issues raised in evidence at Stage 1 did cause me some concern, and my officials had extensive discussions over the summer with the Crown Office and with victim support organisations. Following these discussions, I am satisfied objections should not be possible in relation to those standard special measures which are automatically available to certain categories of vulnerable witness. I believe that this approach strikes the appropriate balance between the rights of victims and the accused, and I am grateful to Alison McInnes. Amendment 64 in my name is consequential Amendment 63 and ensures that where a vulnerable witness notice contains a request for both standard and non-standard special measures and an objection is lodged in relation to the latter, the resulting hearing only deals with those non-standard measures, with the standard special measures being granted as usual. Elaine Murray, through Amendment 65, proposes removing Section 9 of the bill altogether, with the effect that the procedure for objecting to any special measures specified in a vulnerable witness notice in respect of child and deemed vulnerable witnesses will be removed. Furthermore, in Amendment 67, she proposes removing Section 13 of the bill, with the effect that the procedure for objecting to any special measures specified in a vulnerable witness application, which relates to objections to special measures for other vulnerable witnesses, will also be removed. As already mentioned, my officials have had extensive discussions with the Crown Office and victim support organisations on these matters and have given considerable thought to what is required in order to meet the needs of the victim while ensuring the rights of the accused are upheld. It is worth noting that representations can already be made to the Court in relation to special measures, albeit without any formal procedure or process involved, and that this would continue to be the case even if these sections were removed. I consider it more appropriate, therefore, to clarify what can already happen and put this on a statutory footing, while ensuring that those special measures, which are automatically available to certain groups, are not subject to challenge. I do not believe that removing sections 9 and 13 from the bill is the right approach. I urge the committee to support Amendments 63 and 64 and invite Elaine Murray not to move her Amendments 65 and 67.
Thank you very much, Cabinet Secretary. Elaine, please, to speak to Amendment 65 and the other amendments.
Thank you, Convener. I lodged Amendment 65 and 67 after representations from members of the Victims' Organisations Collaboration Forum Scotland, who are deeply concerned about these sections. They believe that giving the accused the right to object to special measures will increase uncertainty and pressure on vulnerable witnesses. These sections could mean that child witnesses who have an automatic right to special measures could find themselves subject to objections and possible loss of those measures. VOCFS argued that it was illogical to extend the rights of vulnerable witnesses to special measures while at the same time bringing in provisions to deny them those rights. Special measures enable witnesses to provide the best evidence to court. These sections appear to be in contradiction to the general principles of the bill. Also, as special measures are provided to ensure that the provision of best evidence, they are not prejudicial to the interest of the accused. Now, I do note that the Amendment 63, in the name of Alison McInnes, removes the right to object to standard special measures, which would go some way indeed to allay the fears of VOCFS. I think this may well be a better way of addressing the issue, actually, than deletion of the section altogether. However, I do ask whether or not there shouldn't be a similar amendment in Section 13 to address the concerns over Section 13.
Thank you very much. Any other members? No. Cabinet Secretary, do you wish to say anything?
Section 13 is a different category dealing with different aspects. So, I mean, I think I welcome the position taken by Elaine Murray. I can understand where she came from. It went in, presumably, at the same time as Alison McInnes. And it does seem to me that if we support Alison McInnes's amendment together with the consequential one to some extent from 64, then we get the right balance and provide the appropriate protection I think Elaine Murray correctly wants.
And now could I ask Alison McInnes please to wind up?
Thank you. Well, I think the Cabinet Secretary is correct that my Amendment 63 with his consequential 64 strikes the right balance in this. I think it is unfair for children who have already automatic entitlement to standard special measures to find themselves subject to objections in relation to their use of those very standard special measures. And it would require them and their solicitor or counsel to justify why they should have entitlement to standard special measures, putting vulnerable children through an unnecessary additional court process. Standard special measures were introduced because they enable vulnerable witnesses, like children, to give their best evidence. Making that a conditional entitlement diminishes the purpose and reduces their ability to give their best evidence. Children and young people often experience court in a very negative way, despite the provision of special measures. Perpetrators often make threats about what they will do to children if they tell about what's happening to them. They may threaten to kill their family or their pets if they tell. For this reason, it is very difficult for children to give evidence in court, as there is a high level of fear. My amendment limits the removal of a right to objection to standard special measures, and I very much welcome the Cabinet Secretary's support for that.
So you're pressing. Thank you very much. The question is Amendment 63 be agreed to. Are we all agreed? Yes. Call Amendment 64 in the name of the Cabinet Secretary. Already debated with Amendment 63. Cabinet Secretary to move formally. The question is Amendment 64 be agreed to. Are we all agreed? Yes. Call Amendment 65 in the name of Elaine Murray. Already debated with Amendment 63. Elaine, to move or not move? Not move. The question is that Section 9 is agreed to. Are we all agreed? Agreed. I call Amendment 66 in the name of Alison McInnes and a group on its own. Alison, please to move and speak to that amendment.
Could I just have a moment to
You can have a moment, yes. I'm whizzing on.
I'm through this.
I'm hoping to get to the end of, while you're looking, the end of section 16 today, which is good pace, and then I'll take it. Then we'll have a break and go on to the next. Not a permanent break, you know. We're busy bees. Right. Have you found it now?
I found my notes. Thank you very much.
Amendment 66, name of Alison McInnes. Alison, please to move and speak to that amendment.
Thank you very much. I'm concerned that Section 10 will remove the assumption that child witnesses under the age of 12 will give evidence away from the court building. This is something that the committee heard evidence on and raised some concerns. This is seeking to address poor practice through statutory provision. The law, as it stands, established in Section 271A of the Criminal Procedure Scotland Act 1995, is sufficient in enabling children to give evidence in person, should they wish to do so. Indeed, it presumes that they will give evidence away from the courtroom unless the child has expressed a wish to be present, or where the risk of prejudice to the fairness of the trial and to the interests of justice outweigh the risks to the interests of the child. As our Stage 1 report noted, the Scottish Government's justification for removing the existing presumption through this Section 10 is that it is being too rigidly applied by the courts. It is argued that it has led to children being required to give evidence remotely and separately from their parents who are in court. However, Children First point out that rather than legislate further, training and guidance needs to be improved to help better present the options to children and young people on how and where they can give evidence. We need to be more sensitive to the needs of vulnerable families. We've heard the Cabinet Secretary speak earlier about the need for flexibility, and I believe that my amendment would give that flexibility. Creating new categories of vulnerable witnesses, extending special measures to more distressed adult victims will help overcome any perceived problem. My amendment therefore seeks to remove Section 10 entirely to ensure that this bill does not have the unintended consequence of empowering other people to decide when a child should be in court, perhaps even against their will. And I move Amendment 66.
Thank you very much. Any other members? Roderick and then Elaine, please.
Yeah, in relation to this measure, we obviously have a difference of opinion between Children First and the Children's Commissioner. I kind of side with the Children's Commissioner on this, that the bill that's drafted will actually give more choice to the child, and don't share the concerns of Children First on the issue.
Elaine?
Say that I'm supportive of Alison McInnes's amendment. Gave consideration to something on the same lines myself. I think there's a serious concern there expressed by representatives of children's organisations that children could be compelled to give evidence. Young children, this isn't 17-year-old ruffians or whatever, this is children under the age of 12, and I think they need to be protected.
Cabinet Secretary.
Amendment 66 will remove Section 10 from the bill so that the current presumption that children under 12 will give evidence away from the court building and trials concerning certain offences will stand. Section 10 of the bill makes a very minor amendment to the existing legislation to place greater weight in the views of the child, the result being that if a desire to give evidence in court is expressed by the child, then there is a presumption that this will be allowed. The intention is to give children greater freedom to give evidence in a manner that will be of least emotional stress and upset to them, improving their experience and potentially resulting in better quality of evidence from them. The changes made by Section 10 were proposed in response to feedback from victim support organisations such as Scottish Women's Aid, Rape Crisis Scotland and Assist, who indicated that the current presumption may be being applied too strictly, with the result that children who wish to give evidence in court are being forced to do so from a remote location. For example, a child may wish to give evidence in court to prevent them from being separated from a parent who is required to be in court for the proceedings. The change made by the bill will not force child witnesses to appear in court, nor will it make significant changes to the current and sensible presumption that young witnesses should give evidence remotely. What it will do is provide that where a child witness has expressed a desire to give evidence in court, that preference is heeded unless there is good reason why this would be inappropriate. I believe that Section 10 will give children more choice, not less, a point welcomed in the 30th April committee session by the Children's Commissioner, and I therefore cannot support Alison McInnes's amendment.
Alison, wind up, please.
Thank you. I've listened to what the Cabinet Secretary has to say, but I will press my amendment. Some children have told us things like this. I know I should feel better now that he is in jail, but I keep having flashbacks of court. That's a 14-year-old boy who probably thought that it would be okay to give evidence in court. A 15-year-old girl who was a victim of an attempted rape. When I entered the courtroom, I was really, really scared. There were all these people staring at me. The lawyers had wigs. The judge didn't say anything to me except to tell me to stand. There were all these people taking notes about what I was saying, and the accused was always in the corner of my eye. The court day was the worst day of my life. I think that we need to listen to the voices of young children and protect them, and I would press my amendment.
Thank you very much. The question is that Amendment 66 be agreed to. Are we all agreed? There is not an agreement. It's a division. Would those in favour please show? Those against please show. Abstentions? 4, 3, against 5, 1 abstention. That amendment is disagreed. The question is that sections 11 and 12 be agreed to. Are we all agreed? Call Amendment 67, the name of Elaine Murray, already debated with Amendment 63. Elaine, to move or not move?
Not moved.
Not moved. The question is that Section 13 be agreed to. Are we agreed? The question is that sections 14 and 16 be agreed to. Are we all agreed? Now, I can actually stop here if you wish, because that's the sections dealt with. We've come to the end. Are you content and we move on? We have a short break, then we move on. My apologies to John, but I think it allows us to have a bit of a break before we go on. Well, can I just thank the Cabinet Secretaries and officials for attending today, and we now move into private session. Thank you. I'm also going to give you